We are in a Texas courtroom, and within the first 60 seconds, the stakes could not be higher. A 21-year-old father of two is standing before the court, charged with assaulting a pregnant woman, his own partner, just days before she was set to deliver their child. This isn't just another docket call. This is a third-degree felony. Assault of a pregnant person, carrying 2 to 10 years in prison and up to a $10,000 fine. And the judge, she is not here to rubber stamp anything. What makes this case explosive is what happens next. There's a plea bargain on the table. There's an affidavit of non-prosecution from the alleged victim. And yet, despite the agreement between the state and defense, the judge hits pause. Why? Because the plea deal includes no contact provision. And when the court reads the allegations, bruising, swelling, busted blood vessels in the eye of a pregnant woman, the tone shifts dramatically. This isn't just about punishment. It's about protection. It's about cycles of abuse. It's about what children learn from watching their parents. And the judge is about to make it crystal clear. She will not ignore red flags just because the paperwork says agreement. Then, as if that weren't enough, the courtroom pivots to a completely different case. A 17-year-old facing aggravated robbery charges, a first-degree felony, 5 to 99 years, prison time, deadly weapon finding. 2 cases, 2 young men, 2 very different crimes. But the same question lingers. How did they end up here so young? Stay with this one, because the judge's words are about to cut deeper than the sentence itself.
23 CR 3546, State of Texas versus Larry Casillas. Can I have parties announced for the record for the state?
House thanks the state of Texas.
Defense?
Elizabeth Russell for Larry Casillas.
Are you Larry Casillas? Counsel, have you received all the discovery? Did you review it with your attorney?
I have reviewed.
I'm sorry, with your client.
Yes, Judge.
Court will find that the state is in compliance with discovery. Showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented? That appears to be a yes.
That's it. We're proceeding on count 1.
All right, there's only one count in the indictment.
Yes.
All right. Showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with assault of a pregnant person? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
All right, we can go off the record. I'm looking at this plea bargain agreement.
Right here's where things get tense. The defense is explaining that the alleged victim, Stephanie Ortiz, requested no contact order for convenience in co-parenting. She even filed an affidavit of non-prosecution. And in many courtrooms, that might carry weight. But this judge draws a hard line. She makes it clear. Just because a victim requests something doesn't mean the court will follow it, especially in cases involving alleged violence against a pregnant woman. That's a key legal principle here. Protective orders and no contact conditions aren't just about what the victim wants in the moment. They're about public safety, long-term risk, and patterns of behavior. The judge even offers them an out. Withdraw the plea and go to trial if you want. That's bold. That's a judge saying, I'm not negotiating safety. And here's the bigger question for you watching. Should courts honor victim requests in domestic violence cases when safety concerns are this serious? Or is it the court's responsibility to override that for protection? This moment sets the tone. This is not going to be a casual sentencing.
And there's to be no harmful or injurious contact with Stephanie Ortiz?
That's her by her request, Judge.
I'm not following. I'm not going to follow that.
Even though that's her request.
No, I mean, no, even though it's a request, according to what I'm about to receive, he is a person who is hitting on, not in a loving manner, a pregnant person. I mean, was she pregnant at the time?
Yes, Your Honor.
So if, you know,
She's
I-
requesting, and I'm sorry, Judge, may I speak?
sure.
She's requesting it for her convenience. They've been doing custody exchanges for the last almost a year through a third-party person, and it's her request. She reached out to me, filled out an affidavit of non-prosecution and requested that. So
I'm not following that. So if you all want to withdraw your plea now, you can. But I am not doing a no harm for injurious contact for somebody who's accused, and I haven't read the steps yet, who's accused of hitting a pregnant person.
that's fine, Judge. They're no longer in a relationship. The only relationship is for the benefit of their children. He has no interest in communicating with her beyond that.
All right, so I'm not going to follow that. So y'all have a choice. Either you can go to jury trial or either you all can change that part of your plea bargaining agreement.
We're proceeding with the no contact, Judge.
All right, if you all want to change that. Court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
We are, Judge.
Anything you wish to say on behalf of your client?
Judge, we would just request that you follow the agreement between the state and defense. Mr. Casillas is wanting to move forward in a direction that's appropriate for his children. He understands what went wrong and he wants to take full responsibility for that. And he has had no issues since the arrest on this date, and they have been successfully co-parenting since that time. There was a CPS case, Judge, that was closed out for no finding.
All right, how old are you?
21, Your Honor.
How many children do you have?
2, Your Honor.
What are their ages?
1 year and 6 months.
1 year and what?
1 year and 6 months.
Are you employed?
Yes, Your Honor.
What do you do?
I work at Amazon at facility warehouse.
All right, so why do you keep hitting on Stephanie Ortiz? At one point, I'm assuming you loved her because you have children with her.
Yes, Your Honor.
So why do you keep hitting on her?
It was just me not being in the right state of mind, me letting my feelings get to myself and not just thinking right and thinking straight.
That makes no sense to me.
Your Honor, it was just my fault. I let my feelings get to myself, let her get in my head and
Let what?
let her get in my head, and I just reacted in a wrongful way.
No, but I mean, you're up here hitting someone. Honestly, I don't even know why I should follow this plea, but your attorney is telling me that she's filed a affidavit of non-prosecution.
This is where the emotional weight hits hard. The judge references the police report: bruising, swelling, busted blood vessels in the eye. And more importantly, this was allegedly not the first time. Now legally, even though the victim filed an affidavit of non-prosecution, the state can still proceed. Domestic violence cases often move forward without victim cooperation because prosecutors recognize the cycle of abuse and the pressure victims may face to recant. The judge's reasoning for the no contact order becomes crystal clear here. She's looking at patterns, she's looking at escalation. She's looking at the fact that the woman was pregnant, close to her due date. That aggravates the emotional and moral weight, even if the charge remains a third-degree felony. And when the defendant tries to explain it as letting feelings get to his head, the judge doesn't let that slide. Because here's the truth: emotional impulse is not a legal defense. Let me ask you this: does his explanation feel like accountability to you? Or does it sound like minimizing what happened? This is the turning point where the court shifts from negotiation to correction.
But according to this, she was pregnant and she was going to be induced that day, and you decided to put your hands on her. I don't understand how is she getting in your head that you would be hitting a pregnant woman who's about to deliver your child.
No, Your Honor, what that day was in the day we were supposed to get induced. But I believe the hitting was before that. So it was just the marks that had came about.
But you still hit her while she was pregnant and she was close to her due date. Not that it's appropriate to hit anyone anyway,
No, it's not, Your Honor.
but obviously she was pregnant. And what she's saying in this documentation, I want you to tell you the reason why I'm saying no contact,
Yes, Your Honor.
because what she's saying in this police report is this is not the first time that you've been abusive to her. And the police took photos and she had bruising and swelling to the eye along with busted vessels in her eye. That's what you did. So the two children you have, is this a boy and a girl, or two boys or two girls?
Girl and
All right. So
This is powerful. The judge pivots from legal analysis to something deeply personal: his daughter. She asks him how he would feel if his daughter grew up and ended up with someone like him. That's not just rhetorical. That's strategic. Judges often use perspective-based questioning and sentencing to force defendants to confront the human consequences of their actions. She's reframing the issue. This isn't just about him and Stephanie. It's about generational patterns, about what children internalize, about whether violence becomes normalized. And here's what makes this moment so impactful. She acknowledges that he says he loves his daughter. She believes him, but she challenges him. Love isn't just words, it's behavior. Would you have responded the same way if you were in that courtroom? Or do you think the judge crossed into moral lecturing territory? Either way, this is more than sentencing. This is intervention.
What's your daughter's name? Sarabella.
She's a year and 7 months.
All right. So she's a year and 7 months. I guarantee you she knows that you've been abusive to her mom. Do you love your daughter?
I love her with all my heart.
With all your heart? Would you do anything for her?
I would, Your Honor.
I used to do CPS cases and parents would tell me I will walk through fire for my children.
Yes, Your Honor.
They would say that because they knew nobody had a fire for them to walk through.
Mhm.
But I believe you when you say you love your daughter.
Yes, Your Honor.
So how would you feel if your daughter became of age and she ends up with somebody like you who hits on her? Would you be okay with that?
I'll be very upset, Your Honor.
And so your daughter is learning what it means to show love is to hit on people, and might makes right.
Your Honor, that's
You're going to have to change your ways.
yes,
You are not to have any contact with Stephanie Ortiz. And anybody else you get into a relationship yet, don't let them meet your publicist. Let them meet you and tell them, hey, want to let you know I had this abusive acts in my background,
Yes, Your Honor.
because then they can make an informed decision about whether or not they want to date you. You understand?
Yes, Your Honor.
All right, this is what the court is going to do. The court is going to sentence you to 6 years.
Now let's break down what just happened legally, because this is significant. The judge sentences him to 6 years, deferred adjudication. Deferred adjudication means the court does not formally enter a finding of guilt, yet. If he successfully completes probation, the case can be dismissed without a final conviction on his record. But if he violates the terms, the judge can sentence him up to the full range, 2 to 10 years in prison. Conditions include no contact with Stephanie Ortiz, a batterer's intervention program, BIP, parenting classes, 200 hours of community service, regular reporting, drug testing, proof of employment, and restrictions on working with minors or in home health care. There's also an affirmative finding of family violence, which has long-term consequences, especially regarding firearm possession. And this is structured accountability. It's not prison, but it's serious supervision. Do you think 6 years deferred is fair, too lenient, too strict? Let me know.
The court is
But the
going to
courtroom
sentence you to
isn't done
6
yet.
years deferred adjudication. There's to be no contact with Stephanie Ortiz. There's to be the BIP course, parenting classes. That can be with rainbows. There's to be 200 hours of community service restitution. That will be waived once he completes parenting classes. Regular reporting by Zoom or in person. Regular UAs. If you're drug tested today, what are the results going to be?
Positive, Your Honor.
And what are you going to be positive for?
I mean, no, negative, Your Honor.
Negative? Okay. So you haven't used anything.
No, I-
I think Amazon drug tests, do
Yes,
they
yes,
not?
yes, I'm done, Judge. Yes, ma'am.
All right, there's to be regular UAs. I'm going to want field visits one time every 3 months. Proof of employment within 15 days. There's to be no employment as a home health care provider or with minors. There's an affirmative finding of family violence. Probation, is there anything else he needs?
You already did mention the regular.
Yes. All right, is there anything else you need from the court in order to be successful? 2023 CR 2528 and 2023 CR 2529, State of Texas versus Berlio Marquez. Can I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense.
Robert Maurer for defendant, Your Honor.
And are you Mr. Marquez?
Yes, ma'am.
Counsel, have you received the discovery in each of these cases and did you review it with your client?
Yes.
In each cause number, the court will find that the state is in compliance with discovery. And each cause number I'm showing you was entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, in each cause number, do you waive the reading of the indictment?
I did.
State, are you proceeding on the indictment as presented in each cause number?
We are, Your Honor.
Mr. Marquez, in each cause numbers, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review those documents with your attorney? Did you understand them? Did you sign
Now the
them in
tone
all the
shifts
appropriate
entirely.
places?
A 17-year-old.
Did you understand in
charged
each
with
cause number?
aggravated robbery, a first-degree felony. That means 5 to 99 years, or life. And the judge finds him guilty pursuant to the plea agreement. 5 years in prison. Deadly weapon finding. That deadly weapon finding is huge. It affects parole eligibility and classification inside prison. And the sentences are concurrent, meaning they run at the same time, not stacked. Legally, this was a plea bargain the judge followed, and because of that, and because he waived his right to appeal, he cannot challenge this sentence later. That's final. But then comes something we don't always see. The judge speaks to him directly, not about the crime details, but about his future, about not becoming institutionalized, about finishing school, taking college classes. I'm 17 years old and heading to prison. Here's the question. Is 5 years enough to rehabilitate? Or is entering prison at 17 a pipeline into deeper criminality? This is where justice and reality collide.
You're charged with the offense of aggravated robbery. That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand? After reviewing states exhibits 1 and attachments in each cause number, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge, but ask to waive PSI.
Anything you wish to say on behalf of your client?
Just ask you follow the plea bargain here.
All right. And the cause number ending in 2528, the court will find you guilty, sentence you to 5 years in the prison, give you credit for any time served. There's an affirmative finding of deadly weapon. This will run concurrent with 2023 CR 2529. Taking consideration 2023 CR 2621, 2527, 699185, and 184. There's to be restitution, if any, to Isaac Cervantes, Cameron Carroll, Kyle Sutherland, and Stephanie Lefebvre, and also no contact with any of those parties. And then in cause number ending in 2529, court is finding you guilty, sentence you to 5 years in the prison, credit for any time served, concurrent with 2023 CR 2528, taking consideration 2023 CR 2621, 2527, County Court Cause number 699185, 184, no contact, and restitution to the following: Isaac Cervantes, Cameron Carroll, Kyle Sutherland, and Stephanie Lefebvre. I'm pronouncing that name all sorts of ways. I apologize to Stephanie. All right. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is,
2 defendants, 2 very different paths, but the same underlying theme: accountability at a young age. In the first case, Larry Cassis avoids immediate prison through deferred adjudication, but under strict conditions, including a no-contact order and family violence finding. The judge made it clear that victim preference does not override court-imposed safety measures. In the second case, a 17-year-old receives 5 years for aggravated robbery with a deadly weapon finding. The plea deal was honored, the sentence is real, and the consequences are life-altering. What stands out in both cases is the balance between punishment and potential rehabilitation. One man gets structured supervision with a chance to avoid a conviction. The other faces incarceration but is urged to use that time to build a future. A justice isn't always about maximum punishment. Sometimes it's about controlled opportunity. Sometimes it's about drawing boundaries. And sometimes it's about trying, against the odds, to redirect a life before it's too late. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
You need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we're off the record. How old are you?
17.
You're 17 and you're doing this foolishness. If you want things, you got to get a job so you can have things. You understand?
Yes, ma'am.
For a 17-year-old, you've chosen a hard road for yourself because you're going to prison, 17. And you're going to be in prison with a bunch of people who are there for murders and other things. When you go to prison, don't become institutionalized. You're 17, you still have a chance to make something out of yourself and do better in your life. So keep your head down and do your time and try to improve yourself. You could even take college classes while you're at the prison. And if you dropped out of school and don't have your high school diploma, you can get your high school diploma while you're there. So don't come out of prison having just wasted time, okay? All right, good luck to you.
Thank you, Judge.